All right. So, hello, everyone. Before we begin, ask yourself a simple question. What happens to your clients if something happens to you? Welcome, everyone. I'm Maya Bovshow, CEO at Trust Properties USA. We're the leading trust and probate real estate brokerage, serving thousands of families over the last 25 plus years. I'm excited to be joined today by my friend and a true leader in the fiduciary profession, Marguerite Lorenz, to discuss Don't Leave a Mess, professional succession planning for attorneys and fiduciaries. She's very well versed in this area. And if you are just meeting Marguerite first time, she is a recognized expert fiduciary, author, educator, and a passionate advocate for raising standards across the trustee industry. Um, in today's conversation, we'll be exploring the critical role of succession planning and the professional ethics that guide exceptional fiduciaries. So we call it planning our exit as we enter. We're also going to have a great Q&A session. So you're going to have a lot of questions throughout. Please drop it in the Q&A, and we're going to do our best to address as many of your questions and comments as possible. And of course, for taking the time to learn, we're going to have a $100 Amazon gift raffle at the end. So stick around for your chance to win. And just a reminder that this webinar is recorded and it will be sent at the end to all of you. So again, thank you so much for joining. And Marguerite, thanks for being here. Let's dive in.
Thank you so much. Thank you. And just a reminder, the recording will probably be out in the next week or so. So you won't get it immediately at the end of the presentation, but I know you'll receive it in good time. So I'm Marguerite Lorenz. I'm a private trustee and executor, and I am a second generation fiduciary. And I'm talking to you about these topics because I've had the experience of being a successor to another fiduciary's practice. And now I'm in my own transition where someone else is my successor. And so I'm right in the middle of that. And we'll be talking a little bit about what succession means. I wanted to give you this basic concept that, you have a business. And even if it's just you and you have a dozen or so clients and you're operating as a solo practitioner, the question that Maya posed at the beginning was, what happens to your clients if something happens to you? And so you need your own succession plan, you need your own estate plan, and you need those two plans to blend together. So that's what I mean by a flexible succession plan. But you also need good business practices. And we're going to be talking about organizing your information and making it possible for someone else to pick up where you left off. That is as important as the documents that you create to give someone authority to actually do that work. Let's go to the next slide. So we're very fortunate in California that not only is our profession as fiduciaries recognized, but we also have rules that allow for a practice administrator. And part of what we're going to talk about today is what a practice administrator might do for you. So let me give you an example. A fiduciary practice administrator is a neutral third party, often a licensed professional fiduciary or attorney, appointed by a court to temporarily take over, manage, or wind down the business and legal affairs of a deceased, suspended, or incapacitated fiduciary, like trustee, estate executor, or conservator. So this role ensures that active trusts, estates, and conservatorship cases do not suffer from neglect, financial loss, or legal abandonment during an unexpected emergency. But I also want to point out that this requires a court appointment. Who is going to be appointed? Well, it might be the person who's serving as your conservator or serving as your agent on some level. So you have to kind of think about that. And I strongly recommend that you nominate 1, 2, or 3 people. Whenever this happens, whenever you might be incapacitated or you might resign, or in this case, you are suspended from practice, it'll be a surprise. And we don't like surprises as fiduciaries. It's just not efficient. So it's good to consider who that person might be. And here's a little thought experiment of who would you be comfortable with giving a key to your office to? Who would that person be? And start thinking about that person as we talk about this. Also, keep in mind that the practice administrator doesn't get to take over your cases and be the fiduciary of those cases or earn the money from those cases. No, it's their job to make sure that those cases move along to where they need to be. And maybe they have to marshal or administer something in the meantime, but it's not that someone else would become the fiduciary. You can build that. You can create a successor to your practice that's a little bit different than having a practice administrator. And I'll explain more in a bit. Let's go to the next slide. So the powers of a practice administrator, you can take a look at this list, and that makes a lot of sense. I wanted to share with you that there's also the continuity of care, taking over the day-to-day management of your vulnerable clients. So you might have seniors or minors or special needs folk that you are looking after and paying their bills. You might have some things automated, but we still need to be vigilant, right? We still need to make sure that those transactions are handled properly and correctly. And so it's not just naming a person who would do this work for you. You might want to invite that person into your practice to see your day-to-day and to see how you manage things. There's also the asset protection, securing and managing bank accounts, real estate, and investments to ensure beneficiaries do not face financial damages or big gaps in terms of having their needs met or their bills paid. There needs to be a transition and an accounting of that transition. So this is another duty of the practice administrator. They have to identify all the open matters. They have to finalize any pending tasks and transfer duties to a permanent successor fiduciary or closing out the estate. So when you think about pending tasks, where are you keeping records of what you've already done and what you're about to do? And that becomes very important in terms of someone sitting in your chair and being able to do your work if you can't do it yourself. There's one more piece, that's legal compliance. There may be fulfilling all court-mandated reporting, tax filings, and legal obligations required of the original fiduciary. We can go to the next slide. So when we talk about the specific tasks of the practice administrator, I want you also to layer in the possibility of your successor in your practice. And do you have a successor for your cases? And what do they know about the cases that you're currently working on now? I think periodic updates with whoever might be your successor is just a good idea. That way they know, for instance, that you've already sold the house or you've already consolidated the funds and you're ready to make distribution. It's just so good to be able to check in with someone who might take over for you so they know where you're at and how you handle things and what your preferences are. But you also might have a successor to your practice. And so I just want you to think about who in your life knows where to find your files, your contacts, your documentation, your task lists. Who is your person if you are too ill to proceed? And I want to add another question. Who would you make responsible if you go on vacation? That's been a big question in my office. Mom invited me to be her partner, and mom is Jane Lorenz. She's my stepmom. And she invited me to be her partner. And within 3 months or so of my working with her, she left for 5 weeks and went out of the country. And of course, someone died during that 5 weeks. But we had a company credit card that my name was on. I was able to manage and hold things still, if you will, for a little bit, communicating with people, letting them know the trustee would be back, but I am not the trustee. But I was certainly able to respond and hold the place of that person temporarily. So that may be how you handle vacation. If you haven't really thought about it or you haven't been on a vacation for a few years, I'd love for you to start thinking about what that might look like. Let's go to the next slide, please. So there are rules for closing a law practice. And I just want everyone to keep in mind, I am not an attorney. It might be better to think of me as a professional client. I've hired a lot of attorneys during the course of my practice. I've worked with so many, and some people really have a clear idea about the beginning, middle, and end of their practice. And I've been introduced to successors as we've entered into cases together, which has been wonderful. Getting a chance to get to know the next person is so valuable. It's so comforting to know there'll be continuity. So think about that in terms of your overall practice, whether you're a fiduciary, an attorney, a CPA, even a financial advisor. The whole idea is that we want to have that continuity for the benefit of our consumers, of our clients, but also for ourselves. Maybe you can sell your practice in terms of this. Maybe it's a surprise and it's just about wrapping things up. I want you to know there is a sample on the bar website of the rules that you have to follow to wind down your operations. And that would be in compliance with your ethical duties. It often takes several months. You need to transfer or conclude all your client matters. You have to safeguard the client files. You have to close your trust account and formally update your bar status. So, for the fiduciaries in the room, I just want you to consider that your person will also need to inform. Maybe it is NAPEC, the National Association of Estate Planning Councils. Maybe it is your fiduciary license with the Professional Fiduciaries Bureau. You might have to give notice to other entities, other memberships, other certification bodies that this person is no longer in practice. And recently, the California State Bar posted a request on LinkedIn. If you know of any dead attorneys, please tell us. That was so shocking to me. So I'm still puzzled that there are many practicing estate planning attorneys that do not have their own estate plan in place. And I'm not going to shame anyone by asking for a raise of hands who has their estate plan or who doesn't, but it is time. And it is very, very important for your ongoing practice, for your own safety and protection as a human being, and for the people that you serve, that you have all of your documents in order and everything ties together with your practice. And you'll note here on this, hire the right attorney to create your plan. I don't think it's enough for any of us professionals to have just an estate planning attorney. I think we also need to have a business law attorney to be sure that we're in compliance with all the other rules that we have to follow. All right, we can go to the next slide. Thanks, Maya. So reconciling your personal estate plan with your business succession plan. I bought into Jane's practice. So what Jane and I did was that she had been a solo practitioner. She was a CPA who also served as a fiduciary. And then together, after lots of discussion, I think it took us 2 years altogether of talking about what that agreement would look like, how I would be paid, how she would be paid, how we want to handle ownership, how we want to handle executive decision making. And we really talked a lot about what our practice together would look like. And then we converted her sole proprietorship into a corporation so that I could begin buying shares from her. So I was buying Jane's shares. And as I made the purchase, I titled my shares in the name of my trust. So I just wanted to give you that hint. I think it's very important. Also, I didn't have a trust before this. And I wanted to be sure that I was doing things correctly. So I got my first estate plan. And I had other reasons to have an estate plan, which you can find out about in the books I've written, and we'll talk about those later. But the idea is that there was a way for us to have a really good partnership with good communication and comfort and ease on some of the things that get families in trouble all the time, like money and control. And we were able to adjust to changing circumstances because maybe I wasn't able to buy as many shares as I was hoping one year. There were lots of considerations we made in terms of the operating agreement. So it wasn't just the fact that I was buying in. We also had an operating agreement. We had an employee agreement. We also got key man insurance, and we'll talk a little bit about that in the future. So when you think about writing your estate plan, please consider having a trust even if you don't own real property, because it may be about the shares of your business and a good reason to have a trust. We can go to the next slide. So Fiduciaries, like lots of other professionals, we're mandated reporters, but we're mandated really to protect our clients, even at a cost to ourselves. So I believe we have a duty to make people safe. We have successors named in documents, and that means that there's little change for the client when there's a shift, but there might be a big change in terms of your office when that happens, when the shift needs to happen. And that's another reason why I'm really emphasizing you need to have your own estate plan. It's really tough to advise a client to plan when you haven't. And so if you're not in the habit of filing everything when things come in, or you're not scanning all the documents as they come in, this might be a good time and a good reminder to think about maybe it's time to tidy up some of those particular practices. Maybe it's time to hire someone to physically help you in your office. People don't plan to fail, they fail to plan. And so making those practice pieces work for you is really helpful, because that's how someone else would be able to pick it up where you left off. And if you knew you were dying, who would you need to inform? And how will you be remembered? So Jane signed her last resignation document on August 11th of 2017. Her illness took her really quickly. We found out she was ill in February. She had a few good months, but by August 11, her signature wasn't the same. I knew that she was capable of understanding what we were doing, but after that, I didn't want her to sign anything else. And she died September 1. That was August 11, her last resignation signature, and she passed September 1. So, I cried signing checks on her cases. I got about half of her cases. My brother Clay, her son, got the other half. We also had another partner at the time, and Noah was an attorney himself, but he also took the court cases that Jane was involved in. I will tell you that the succession was very challenging. It was hard. We were doing the right thing for the right reasons, and sometimes we'd cry on each other's shoulders, and then we'd keep going. And my whole staff was sad. We actually got a grief counselor for our staff because of all the stuff we were processing. And of course, we see her name over and over again. And Jane is still with me in a sense today. But that first couple of years after her passing were very challenging. So it's not just a business legacy. The people who care about you, who are going to try to help or do what they can if you can no longer do it, they need your love now and your planning now. And we also built a culture. It wasn't just about passing on work. It was about our life satisfaction in doing the work. And that had a lot to do with how we communicated about it and the fact that we talked to each other about each other's cases all the time. And so our cases went well because we were receiving each other's wisdom and each other's objectivity. And I will tell you, estate planning attorneys who are thinking about writing your own plan, I know you can do it, but you cannot be objective about your own circumstance. And it's so powerful to let someone else see what you're doing and what you're working on and allow that person to ask you their questions. Let's all have really good planning because we're working with each other and getting each other's wisdom in terms of how we're putting this together for ourselves. So I just want you to know that my brother Clay has been with the business for 15 years now. Noah's been with us for probably 10 years plus. We have lots of people on our team that have been with us a long time. And I am no longer accepting any new cases. So thank you for everyone who's ever named me. I appreciate it. I have a succession plan. I have successors now that will take those cases instead of me. We can go to the next slide. So I spent years buying shares from Jane, and she was my mentor and my partner, and she had an established practice that I was buying into. So I know how lucky I am. I know there are a lot of fiduciaries who've started their own practices and didn't have that kind of mentorship. You do want to build a working relationship with someone who could cover you and start thinking about your transition. Even if you have another 40 or 50 years left in practice in your mind, it's so relieving. I had such a relief knowing that my succession plan was in order and it could be followed. You can't just hand off court-appointed things. So That's part of consideration and thinking about how that would actually work, how those files would be accessed, how someone else could pick up where you left off. And what communication are you in with your current client? Some of us like to do things in writing. That's my preference usually. Some of us do in-person meetings. Having summaries of those meetings, summaries of your commitments, being able to make sure that you check those commitments off as you go, and making sure that your calendar is not overwhelming. We all need to rest. We all need to take care of ourselves. Succession has to be a conversation with every single client. And it's the same with working with Trust Properties USA. I've had really great experiences, but I also know that they have a team. So it's not as if there's just one person. God forbid something happened to the one person I was working with. I know there'd be somebody else there to finish the job. And I know their documentation. I'm familiar with it. So I know that someone else could pick up. It might take them a week or two, but it wouldn't take them a month or two. And that's the difference that we're talking about. In terms of this list, you need someone to be a successor. That might be someone who's actually named in the estate planning documents after you. You might have partners in your practice. That is not a casual arrangement. That means that there's documents that show that co-ownership and the partnership nature, and also who is allowed to access your particular files and your clients. You might have a protege, someone that you are developing into a future successor. You might be considering a sale or a transfer to a third party. For those of you who just thought now, oh, I would never sell my practice, it's not that you would sell it. It's that when you think about what you need to be able to sell your practice, you're making a better practice. The software you use, the equipment that you use, the contracts that you have to manage your copy machine and your postage, all of those things are components of your business. And if you think about your business as a marketable thing, you will organize it better so it could be transferred to another party. That means you're always at choice and never feeling like you're not enough or your business is too disorganized to transfer it to the next person. We can go to the next slide. So the tasks of your successor will be based on the condition of your current practice. I already alluded to some of these things. I won't dwell on them too much, but I also want to point out if you're outsourcing any of the work, like getting your accountings completed, getting your tax returns completed, or you're handling your billing through some kind of service, maybe you have a subscription software that you're using for that purpose. These things are very important to delineate somewhere, have a record somewhere. If you change software that you've used for a long time, you might be mid-change in your software. And I know how hard this is. I've cried many times when we've migrated data from one software package to another. It's important that all of these big transitions that you might be in are documented well enough. Again, if you couldn't complete it, someone else on your team could. And so I really want you to think about this. You've got a fancy car. You've set the seat exactly the way you like it. The height of the seat, your mirrors, everything is set up for you to drive this vehicle. You get out of the vehicle and someone else gets in it. They are going to make adjustments to that very same seat. They're going to change the mirrors. They're going to change the angle of things. You might want to think about a transition to someone else as a temporary thing. Maybe you are just on vacation. Maybe you'd like to take a sabbatical or take a couple of months to travel, or you're taking care of a loved one who's ill and you really can't focus on things the way you could before. Having those tools built in makes life better. And then when you get back, you can adjust things exactly the way you like to have it. But just know standardization is not a bad thing. You'll want to keep your case records consistently, meaning if you use, we have red files in my office. Every red file has copies, not originals, copies of the important documents we need, like when we go visit a bank or we're going to meet a realtor and locksmith for the first time at the house. I want to have my credentials. I want to have all the documents that give me authority. However you're doing that, you want to be consistent from case to case. And that way, if someone's looking for something, they know how you organized it and where to find it. I had a situation where I had a client who passed away at her own home, and her records were all over the place. It took us a few months no lie, a few months to actually find out that she had real property in other states. And she had a huge art collection. And it turns out that she used to sell art. She had a shop at one point that she closed down, and she just brought it all to her house. The garage was full, the house was full, every place was full. And it wasn't until we found some invoices for storage units that we knew there were storage units. And it wasn't until we found invoices for other things that we found out about the out-of-state property that also had more paintings in it. So there was no way for me to sit in her office chair and find what her life was like and find out where her income was coming from and so on. So I know we deal with that with clients all the time. As my dad would say, we don't get paid to wash clean dishes. Okay, I've got job security, right? Because everybody has some messes. But as fiduciaries, as attorneys, we can do better, and we need to be able to organize things so someone else can understand what's personal, what has to do with our business, and how we organized it. We can go to the next. So my interpretation of this particular rule, and you'll see it listed under the code as 4470E and F, and you can see the words there. I know it's kind of small, so I'll read them. Consistent with the licensee's fiduciary duties, the licensee shall manage the assets of the estate in the best interest of the consumer. The licensee shall manage the estate with prudence, care, and judgment, maintaining detailed fiduciary records as required by law. So I'm interpreting that as you're required to have a continuity plan. When other people are dependent on you to pay their bills, to make sure that things get taken care of, responded to, and answered, and you can't be the one to do it, you have to select in advance someone who can do it on your behalf. So I've taken this very seriously and have developed a succession plan, and it took me a few years. I have been a professional fiduciary for almost 23 years and learned a lot from a lot of other people and their practices. I've seen a couple of fiduciaries pass away, sometimes after long-term illness, sometimes suddenly, and both left a mess. Court intercession was required because those people hadn't named a successor, or there hadn't been one in those particular documents. Their employees didn't know where to go next or what to do. So I feel it. And I just want you to know, I think there's a duty. We have an affirmative duty to make sure that we have a succession plan in place. We can go to the next slide. So you're seeing in the photo here, this is from my company website, which is mytrustee.net. You are welcome to take a look at the How to Name Us button. Plenty of people have imitated this language. Not all of them have imitated it well. So please talk to your attorney. Please talk to the attorneys you know. Ask them what they think about having a succession plan like this. We're very confident about it. We've transitioned a lot of cases. There are matters that were not suitable for us to take. There were matters where it was just better to have a family member or someone had spent most of their funds and they had just passed and there's just one asset left, and it made more sense to have someone else do it, not us. So there's lots of reasons why we might not work on that case. There are plenty of cases that we take, of course, and that we work through. So you'll see the language there allows the president of Lorenz Fiduciary Services to have the authority to appoint a successor. And obviously, you can always go to court. Someone can petition the court. Fiduciaries don't often have standing to bring a case to court to become the fiduciary on that matter. It probably needs to be someone else. Please discuss this with your attorney. Your own attorney in your state or your area will understand more about how the courts operate and what their expectations are. And I just want to put this in your mind as an option, as a tool that we've used with great success. We can go to the next slide. I'm really proud of this book. Jane and I wrote the first Ethics for Trustees back in 2011. We wrote it together. I rewrote it again in 2020, and then I rewrote it again And now it has an audiobook. It is only available at planforthis.com. This particular copy and the audio will not be available at the other usual places. And it has been very valuable to a lot of consumers. So these ethical and moral considerations for planning apply to you also. You as a human, you as someone that will be in the hospital bed, you, the one who won't be able to do the work that you're accustomed to doing today. So it's good to think about that. This particular book also was written to help lay people, trustors, really think about who they wanted to have serve. If it is still their family member after reading this, great. Let's give the family members a chance to learn about what's going on, where the assets are, how that particular individual trustor manages their home office, and where things can be found. There's another point I want to make also, and that is that so much is happening electronically that it's very likely that there's not going to be any mail forwarded. There's not going to be any way to know who someone is doing business with if they've done everything entirely online. And you won't necessarily have access to someone's cell phone when they become ill or they pass. So we've got to add that into our intake process as fiduciaries and even as estate planning attorneys to really think that through and to talk to someone about their personal finances in terms of how and where they're doing that business. There are still brick and mortar banks and financial companies, that's true, but a lot of things are handled by phone. A lot of things are, believe it or not, handled by fax, email, and letter. And so as you're creating your own estate plan, I think that if you have your intake list with you also, you're going to be better at managing the client's expectations and getting more information from the client, because now you're seeing it from their side of the equation of actually having to prepare a detailed estate plan. And we talked about this before, how this will transition easily to the next fiduciary. And I'm just recommending to everyone to please work with a business law attorney. You know, fiduciaries really can't have an LLC in California. We can't limit our liability. And there may be other business arrangements that would work for you. But you can't just transfer an open matter with human beings in it to just someone else unless you have the authority to do so in the documents. Or you have to go into court to modify that document. And there's going to be a cost for that. And you could be criticized for spending estate funds to deal with your own emergency, right? So we want to think about this in advance. As we started the talk, we want to plan our exit as we enter, and we want to plan that exit everywhere we enter, whether it's in business with another person, whether it's that new matter. Every new case, we should think about, what does it look like when it is complete? I've talked with Maya about this a lot. Being friends, we've had lots of talks about both being CEOs of family businesses. And it's just so important to think about who I am in this, but also that transition, all the pieces and parts and all the things that we really want other people to enjoy. We built all this, and now it's relatively easy because we know what to do. We want whoever succeeds us to be able to have that kind of confidence also. And then there's just one more note on this particular slide. Self-care. It's just little words on this long list of things, but I want to say it's so important that you find a way to actually rest. And I will tell you that driving on the 15 freeway became an entirely different experience once I got my own estate plan done. I was a single mom with 2 little boys. I was actually living in a trailer on my mom's property, learning how to be a fiduciary. I lived there for 2.5 years, went with her to her meetings, and so on. I did not take a vacation my first 10 years of being a fiduciary. I'm not recommending that to anyone. I just couldn't figure out how to do it. And now that I know, that's why I'm here and that's why I'm sharing it with you. I really want you to have the freedom to live a good and healthy life because you're so important. And when the work you do matters to so many people, you matter. So thank you for taking good care of yourselves. I hope that also is encouraging you to have a little sip of water. I'm going to take one right now. We can go to the next slide. Okay, So I've actually written 3 books, and all of these will be available as of July 1. And I'm really hoping that you come to my website, planforthis.com. We are not selling trust services. We are not selling estate plans. What we're offering is really good education for people so they can think about their own estate planning. This is true for professionals. It's true for lay people. It's really true. Everyone needs to have a plan. And I'm so sad that it's still, the statistic that was true 23 years ago when I started is still true now. Only about a third of American adults actually have an estate plan in place, a written plan. I would argue maybe half of those won't work because they haven't revisited it. They haven't talked to their successors. They haven't told their successors anything. But there's plenty of work for all of us, and especially if everyone gets their estate plan done. More and more fiduciaries are needed, and you are amazing human beings for what you take on, and I appreciate you. So my books are Luck or Control, How to Be a Successful 90-Year-Old, and Ethics for Trustees 2.0. All of them have audiobooks, all of them have paperbacks, all of them have ebooks. I'm sorry, I take that back. Ethics for Trustees does not have a paperback at this time. It just has a PDF for you, but you'll find that on this website. So planforthis.com. Thanks for visiting when you can. I'm ready for the next slide. Okay, full disclosure, I'm a board member of the Independent Trustee Alliance. This is a national nonprofit association supporting the work of independent trustees everywhere. And we have some pretty extraordinary membership benefits. There is a certification program. And through that certification program, you can be certified as an independent trustee. That's 5 years or more of experience. If you have 10 or more years of experience, you can be a master certified independent trustee. And with those, you can actually get a discount on your liability insurance. So that's worth taking a look at. We also have included online excellent video education available, MCLE level, on all of the education. And we have a very big library. And if you do choose to speak for the ITA, your recording will be on our library for 5 years. So take a look at trusteealliance.com. There's other benefits there. We even have access to health insurance. So do take a look. It doesn't cost very much to join, and everyone is welcome. So thank you for that. And we can go to the next slide.
Thank you, Marguerite, for all of those resources. Amazing opportunities for everyone to get involved with ITA and also all of your podcast listening and resources on the plan for this website. I wanted to share a success story of succession. Both Marguerite and I are second generation business leaders. On the top left, you can see that's my father, Larry Bovshow, his business partner, Paul Hargraves. They started Trust Properties USA 25 years ago, and they were the first company to really be the advocates of the estate, to be the one call solution for families going through the probate or trust process. And I was their protege. This is the family business in which I grew up in, and I'm now their successor, CEO of the company. And I'm so proud to see everything that I've learned, the processes, the documentation, uh, how we were able to take it from one office in LA to 16 offices throughout California, Florida, and a nationwide network. And I promise you, if we can do it, you can do it too. And also, there's Jane Lorenz, um, who is the amazing mentor behind Marguerite. And you can see now their extended Lorenz trustee fiduciary family, and the success that they've had. But Marguerite's given us a roadmap here, the considerations that go into creating a business succession plan. And I'm not going to sugarcoat it. It's not always easy. There's a lot of difficult conversations, but it's meaningful and it gives longevity and continuation to your and continuity in your business. So, God forbid anything happens to you, you have a team, a person, and your processes all documented for someone to take over and keep your legacy going.
I want to add one more little thing on this particular slide. There's the lady in the middle wearing the purple sash. She started with my mom way back when and retired after 46 years of working with our company. So I just want to thank Becky out loud. And, that mentoring, that culture of mentoring was really part of the whole team. So thank you.
Yeah. Yeah, it takes that's a big testament to the kind of culture you've built. That's a decision to stay for 45 plus years. So go Becky. And although I am, the child of one of the founders, I plan to stick around. This is something that's very rewarding and meaningful. And I wanted to give a brief case study and show how we work with attorneys and professional fiduciaries. Probate and trust real estate, many of you are well aware, the average estate is going to lose anywhere from $50 to $200,000 because the home is sold with all of its challenges. So the seller challenges, we've seen family conflict of every kind, out of area management. The house is in LA, the family is in New York. Grief and heightened emotions. It takes a lot of empathy and patience, and it's not a standard deal. And then limited access to cash. When you're managing an estate and inheriting a property, who's going to put up the money? And on top of that, the home has several challenges as well. It's filled with personal property, memories, and things that need to be taken care of. Tenants, occupants, squatters. Where's the solution for that? Deferred maintenance. A lot of times, homes that you see haven't been touched in 50 plus years and need a lot of help. They're not even lendable. And on top of that, the home is oftentimes uninsured, there's mortgage in arrears, and there's back taxes. So a lot of things that to project manage. So that's where Trust Properties USA comes in as the one call solution. We work with all of you to handle the estate from A to Z at zero upfront costs. So we put up the money to support with evictions and lockouts, renovations, personal property sale or disposal, homeowners insurance, foreclosure avoidance, property security, any contingency you can think of real estate. Over the last 25 years, we've built a process and procedure to address it. So we love being a relief for the families and the professionals that we work with. I wanted to shout out our Inland Empire Territory Leader, Elizabeth Miffleton, for this recent sale where she helped a family gain an additional $195,000 with our fix and sell strategy. The family, as you can see on the top, very cool and retro, green shaggy carpet, and the home was in disrepair, but the family didn't have the funds to put it up and maximize the equity, and they really needed the money. This was the last big paycheck. So Trust Properties USA fronted $125,000 to put this home into top market condition, selling it at $1.25 million, and the sellers were very happy. So now we wanted to open up the floor for Q&A. I see that we have some in the Q&A section. I'm going to start with Camilla, who asks, has the language for successorship ever been contested? Marguerite, I know you shared some language a little bit earlier on your website. I believe that's what she's referring to. What do we have to say about that? Oops.
In terms of a contest of that particular language, I have not experienced a contest to it. There have been folks who've asked for a specific fiduciary to be appointed and have participated in the selection of an alternative fiduciary. And that's been fine. If we're not going to do it and the family really wants someone in particular, and if that person's a good fit, it makes sense. We still have a fiduciary duty to the trustor who's not making this decision. But no, there's never been a contest that I'm aware of.
Wonderful. And another question, it says, who is the best person to serve as the practice administrator? Another fiduciary in your office or an attorney? I heard that naming another fiduciary in your office or your business partner can create a number of conflicts. What is your opinion on this?
Oh, that's really a good question. You know, for me, I really have made an attempt to introduce my successors in business as successors in the documents under which I serve. So in my succession plan, it's made a lot of sense to transfer cases to my younger successors as I'm stepping out of the practice. I know that may not work for everyone, or you may have a long time case and you don't want to have to go to court for that. As far as practice administrator is concerned, I think that it depends on your comfort level and how much you want to share about your current practice today. And are you willing to talk to that person every year and update them, which cases you've closed? Like every time we have to update our fiduciary license, which is annually. We have a list of all of our open cases and all of our closed cases, and we have to explain why our closed cases are closed. That might be a good time to update whoever you've selected as your practice administrator to let them know what is still open and what's been closed. You might want to have that person physically come to your office or come to your storage unit and see how you keep things and where things are. Because as fiduciaries, we're expected to be responsible for whatever we did or said for the rest of our lives. And that all that record keeping has to go somewhere. So in terms of your business partner, if it's expected that your business partner is also your successor in the documents, you can start now by communicating with the people who normally refer you as to your preference of how you'd like your succession to go. And if you don't have that in place, it may be time to talk with a business law attorney or an estate planning attorney about what your options are for the cases that you do have.
Wonderful. All right, and we have a question here that says from Lydia, can I provide fiduciary services privately and also be a trust and estates attorney?
I'm sorry, I don't know the state the person is in who asked this question. I would think that there might be some rules in your state about it. I
She's in
recognize,
California, based
okay,
on
so I
that.
recognize that attorneys are exempt from fiduciary licensing, but I don't believe that they've received the training that we have received as fiduciaries. Our perspective is different. I've been trained to be the decision maker, and most attorneys are trained to be the advisor, and along with all the protections that come with just being an advisor. So, can you provide fiduciary services? I believe you can. Do you want to? Does your malpractice carrier want you to? And please do read Ethics for Trustees 2.0 before you take this on. It's not just signing checks or managing a trust account. There's much more to being a fiduciary than that, especially if you're going to serve under power of attorney and agent for healthcare. So I'm happy to talk with you sometime. You can always reach out to me. But I'm discouraging anyone from becoming a fiduciary without being 100% fiduciary.
Thank you. All right, we have a question from Paul. Discuss pros and cons of co-trusteeships.
Oh, thanks, Paul. That's a good one. No, I'm just teasing. Co-trusteeships is like having two steering wheels on the same car. I remember talking about this in front of a very large group, and a man raised his hand and he said, "Do you understand how a plane is operated?" I said, "Well, yeah, my dad was an aircraft mechanic with the Navy. I'm aware. There's dual controls. There's a pilot and a co-pilot." So I asked him, I said, if the pilot wanted to go one way and the co-pilot wanted to go another, where would the plane go? And he thought about it for a moment. He said, well, to whoever's strongest. And I said, right, that's co-trusteeship. So co-trusteeship means that each party in the co-trusteeship has 100% liability, but doesn't necessarily know what the other person is doing, or if they raced to the bank and got there first. So I think it complicates things like record keeping. I think it complicates things like transactions. Who's going to pay for what? I think you need to have double the meetings or triple the meetings. I've seen families that have named all 3 or 4 kids as co-trustees. And of course, I get named once it all goes to court and becomes a mess, right? So I'm not saying that it never works. I'm saying that you have to do extra work to make sure that co-trusteeship works. And that's my opinion, my expert opinion. I recognize somebody might have a different opinion. Again, I'm happy to talk to you about it.
Wonderful. Thank you. And from John, we have, how would the pending legislation on allowing fiduciaries to form professional corporations impact succession?
That's a really good question. I don't think the question has been fully answered as to who is liable for decision making. One of the things about banks and trust companies is that they get to keep their conflicts of interest when they become the trustee. They sell financial products. Very often, their trust department is a cost center, but they want to hang on to their profit centers, which is about selling their proprietary financial products and other things. Fiduciaries don't get to do that. So my feeling is that there still needs to be a principal. There still needs to be someone on whose shoulders all this rests. I don't believe we can truly limit our liability as fiduciaries. It's kind of the point of the job. So I haven't looked at the legislation specifically, but I do have serious questions about how it would function, just like you do.
Thank you. All right. And from Teresa, she said, I am in the process of becoming a fiduciary. Where do you suggest I find a firm or practice to find a mentor to get started?
I think you have to interview some fiduciaries to see if they're taking any mentees. The fiduciary work is very full. I will tell you that at the Independent Trustee Alliance, there are water cooler meetings. So that means it's a safe place online through Zoom where you can ask your questions. We actually have time at our conference annually in Dallas, Texas. And by the way, that's always the Wednesday after Mother's Day. And so the meetings in Dallas, Texas, we actually have time set aside where anybody can ask anything of everyone in the room. And we do that intentionally because some things are delicate and you do really need to be able to talk about some of this. And I'm available on a limited basis. So I don't know that you could find a firm that will take you on, but obviously that would be ideal. But keep in mind that asking the same question of a few different people, an estate planning attorney, a financial advisor, a fiduciary, and so on, it will give you some really great answers too. Read my
All right.
books.
And I have read her books and they are amazing. So highly recommend. For one more questions, and we have a raffle from Gregory. He asked, I'm a court-appointed law practice administrator, LPA. The estate has an administrator whom I advise. Is there a template for LPA status report to the court?
I don't have that document. I would recommend contacting the state bar to ask if they have something because they really are responsible for making sure that these transitions happen appropriately. I think it's a great question. And if you find the answer, please post it on LinkedIn. By the way, everyone, please connect with me on LinkedIn. You can always send me a message through LinkedIn. I might write a post about something you ask me, and that'd be super helpful. And if you find a solution to that LPA, that would be fantastic. Let's share it. Let's make sure other people see what it looks like.
All right. And then let's get one more question in here. I'm sorry we couldn't get to all of them, but you have now our contact information here to reach out, and we're happy to chat. From Paul, it says, is there any liability E&O insurance for professional fiduciaries? I can't find any in California.
There is actually join the Independent Trustee Alliance. Take a look at what's there. I think you'll be very pleased. And there are some really great resources there.
Wonderful.
Yeah.
Marguerite, you are a wealth of knowledge as always. Let's get to the fun part.
Oh,
Well,
yeah.
it's
Let's have
been
some
fun,
fun.
but let's see who wins an Amazon gift card for all this learning. We
Woohoo!
use a system that just put in all the registrants in a wheel, and it's going to randomly select based on whatever email you registered with. So let's see, we have, all right, rnncpr92@gmail.com. If you're here with us, please email me at Maya, Maya, at trustpropertiesusa.com so we can connect and give you your Amazon gift card. All right. Well, thank you everyone for joining us today. This is one in our many upcoming webinar series. We will be sending this webinar recording out to everyone. And if you have any questions, Marguerite and I are here to help. And I hope everyone has a great rest of their day. Take care. Bye.
Thanks, everyone. Bye.
Thank you.